State of Arizona versus Edward James Rose, our number CR-23-0315. A couple of things. First off, we are not at full court. We are at full court today. We have two recusals, so Justices Lopez and Bean have recused. So it's just the five of us. Each side, of course, you have 20 minutes. You may keep whatever time you wish for rebuttal, but you have to keep your time yourself. So with that, please begin.
Good morning, may it please the court. My name is Jeff Sparks with the Attorney General's office here representing the state. On the state's view, the key issue in this case is once the defendant established that Simmons via Lynch would apply to his case, whose burden is it to show that application would have changed the outcome? It's our view that under the clear language of Rule 32.1G, in addition to this court's interpretation of that language in cases like State v. Valencia and the broader context of Rule 32, it is the defendant's, in this case Rose's, burden to show that had he received a Simmons instruction that he's ineligible for parole, that the jury would probably have given him a life sentence. First, just looking at the plain language of the rule, it's not enough just to show that the decision applies or to the case. The rule itself says, upon application to the defendant's case, they're required to show that it would probably have changed the sentence. Here, what that means is once Rose can show that Simmons would apply to his case via Lynch, well, what does that mean? That means here he would have been entitled to an instruction to the jury that he is not eligible for parole.
Counsel, let me ask you a quick question on that. and before I get to the question about whether or not he was entitled to a Simmons instruction or whether under Simmons he was entitled to ensure that the jury was informed, which I want to ask if that's a distinction you agree with. And prior to doing that, we asked both parties to address the nature of Cruz III and how it applies here and what the trial court did. And I just want to observe that if the Attorney General in Cruz III had argued as passionately and as adequately as the AG did here, we'd probably be in a very different situation. And this court does not get to appear in front of the federal Supreme Court and explain our decisions. So insofar as you, the Attorney General, represents the state of Arizona, of which this branch is part of the state, we count on you to adequately and thoroughly understand our decisions and brief the federal Supreme Court. So that being said, I hope at the end of this argument we understand where the state's coming from, where the defense is coming from, and that both parties also understand where we're coming from. So we don't get falsely accused of my summary of the federal public defender's argument before the court in Cruz III at the federal level, that we're somehow antagonistic to federal law and federal constitutional rights. We showed this in order to show cause and have them come in here to explain why they misrepresented what this court has done. So with that editorial comment, when we talk about applying the holding of Simmons to the defendant's case here, is it that he was entitled to a Simmons instruction or that he was entitled to have the jury informed about his parole eligibility, which can be accomplished either through an instruction or through argument of counsel?
To answer that question, Your Honor, if you go back to the original Simmons decision, the Simmons itself does say that under the circumstances present, future dangerousness being at issue, parole not being available, that under those circumstances, the defendant is entitled to inform the jury of their parole ineligibility either by an instruction from the court or argument by counsel. I will admit, however, that in the way that the Simmons line of cases has played out, both in the U.S. Supreme Court and both in this court, the focus and the emphasis has been on an instruction by the trial court. The state has taken the position in the past that either satisfies Simmons. I think, however, that given the way that this case law has developed in the U.S. Supreme Court, that the safest course is to conclude that the defendant is entitled to an instruction by the court.
Now, that may be the safest course, but I think the question is whether argument is enough.
Argument is, I will say that here argument is enough when it's the defendant's burden to show prejudice, that the jury was informed one way or another. So even assuming he was entitled to an instruction under the Simmons line of cases, here where it's his burden to show that that would probably have changed the outcome, then the fact that counsel informed the jury certainly meets that burden, or prevents him from showing that an instruction would have changed the outcome.
Mr. Sparks, let me take you back to what you were started out with, which is the burden, because I want to make sure at least that I understand what it is. So under 32.1G, it does have the language that says that defendants need to show there's been a significant change in law and that if applicable to the defendant's case would probably overturn the defendant's judgment or sentence. And then you have 32.13, which talks about the burden being on the state to show harmless error if there's a constitutional violation. So can you explain how those two things interact? Is it simply one is more of the colorable showing in your petition that the burden is on the defense, and then it switches if there's a constitutional violation, if there's an evidentiary hearing shown, or is it something else?
A couple of points there. First, I see 32.13 as a broadly applicable rule, and then you have 32.G, which is a more narrow, specific rule. So the way I see the interaction here is that the narrow rule applies. When you're proceeding under Rule 32.1G, which does put that specific burden of showing prejudice on the defendant, 32.13 doesn't come into play, because there's really no way that it could, because if you apply the straightforward language of 32.1G, clearly that puts the burden on the defendant. Once they've met that burden, I don't think it would make sense for the state to have to then come in and prove harmlessness. I think 32.1G stands on its own there. I see 32.13 coming in most commonly when you have a claim that is developed under 32.1A, which provides for relief for constitutional violations. There's no prejudice or harmless error standard under that ground for relief. So in a situation like that, if a defendant showed that there was error under 32.1A, then I think 32.13 then makes clear that the state has the opportunity to come in and show that that error was harmless.
Is there any allegation here that the Simmons error was brought under 32.1A?
Certainly not in the court below. I think it was very clearly raised and litigated by the parties and addressed by the Superior Court as a 32.1G claim. There's been some suggestion in the briefing here that potentially it could be raised under 32.1A. The problem there is that this claim would clearly be precluded under 32.1A. Whether it was raised, there's been some suggestion as well that maybe it was raised below. So there was a request at trial. That's clear in the transcripts for Simmons' instruction. The trial court, under the case law existing at the time, denied that request. It was listed in the appellate brief as an issue kind of in a footnote to avoid preclusion. This court stated on its opinion that it declined to address those issues. I interpret that as those claims were waived because they weren't developed. So under that interpretation of how it was handled on appeal, then the claim would be precluded under 32.2A2 for waiver.
Well, my question is a little more basic than that. It was simply, has there been an allegation in the PCR petition that the Simmons error under 32.1A at all? Or is it just a 32.1G claim?
I'm sure Mr. Mills will correct me if I'm wrong here, but my understanding of the PCR record is that the parties were litigating and addressing this claim under 32.1G only, and that's the way the Superior Court was.
And then the follow-up to that is, was there any, because you said they were, I guess, litigating some of this, but you're saying it's precluded if it was under 32.1A. Has the trial court actually weighed in on that preclusion for a 32.1A claim versus for Simmons, not Atkins, but Simmons?
I'm not sure that it has, Your
Okay.
Honor.
Counsel, may I ask you a question? This is also related to burden, and if I understood your argument right, it would be in the first instance when the defendant files their petition that they've got to satisfy the elements of 32.1G with respect to the Simmons claim. And then what? If the court finds that the claim is colorable, holds a hearing, what is the state's burden at that point? What does the state need to do? Is it simply rebut the argument and the burden stays on the defendant?
It probably depends on the nature of the claim. Some claims might be suited for a hearing, some claims might not. They might be more record-based. So I think once the defendant has established that the applying the change in the law would probably have changed the outcome, I think then you would have a claim where relief should be granted. 32.13c is still there, although it's hard to envision a scenario where a defendant can show that there was a prejudicial effect and the state could still show that that was somehow harmless. Those are inconsistent.
Okay. And that was a much broader question. So to narrow it down for us here then, so if the defendant's made an argument and let's say in the alternative, we go ahead and we entertain that Simmons was a significant change in the law. And when we look at, would probably overturn the defendant's judgment or sentence. In this particular instance, because we're looking at the jury verdict and determination, do we apply the same sort of standard in looking at overturn that, would a reasonable juror have decided otherwise? Is that what we're looking at here?
I think that's correct, Your Honor. And that's because of the nature of the claim here, of the Simmons claim, because as we were talking about earlier, what Simmons allows is for the defendant to inform the jury that they're parole ineligible. So I think the way to look at that here, and that burden would probably have overturned the judgment or sentence, was if the trial court had instructed the jury that Rose was parole ineligible, would the jury probably have come back with a life sentence verdict?
And on that point, if I may follow up, if we were to find, though, that if we were to stay, I think, true to what Simmons originally held and what was discussed in Ramdes afterwards, that's how it's pronounced, that you can either meet the Simmons requirement through an instruction or by informing the jury through attorney argument. If we were looking at 32.1g and we were to say, okay, we'll treat Lynch as a significant change in the law, we'll say it applies to the defendant's case, but it couldn't have overturned it because the defendant was still able to inform the jury of the nature of parole or release eligibility. Is that as legitimate a resolution of this as focusing on whether or not if the jury had been given the instruction, would a reasonable juror have decided otherwise?
Just to make sure I understand the question, I understand Your Honor is asking would it resolve the question if the defendant had the opportunity to inform the jury whether or not they were instructed?
Let me know the context a bit for you. Let's say that, let's set aside the consideration or the inquiry into if the jury had been given a specific instruction on parole eligibility as discussed in Simmons, but instead, which would then require us to look at, well, if they'd gotten the instruction, would a reasonable juror have decided otherwise? If we were to apply the other half of Simmons that, well, the defendant at least has to be able to inform the jury through instruction or through argument. If we were to find that, well, there was sufficient argument here, the change of plea hearing and everything else, if we were to find that satisfactory for informing the jury, then would we really need to even consider if they would have decided otherwise? Because in some sense, then we could say that, well, actually the letter and spirit of Simmons was complied with here.
Potentially, yes, I think so. The facts here are a little bit different, I think, because I think it depends on how narrowly and specifically you want to look at the holding of Simmons, because it specifically talks about ineligibility for parole, and parole wasn't, or the lack of parole wasn't specifically what the counsel informed the jury of in the closing argument here. It was a reference back to the jury being played the recording of the change of plea hearing when the trial court went over the potential sentences that Mr. Rose would be facing for all of the other non-capital offenses that he was pleading guilty for. And the argument was, you heard all of these other sentences he's going to receive. He's going to serve the rest of his life in prison. That's a little bit, it's kind of two sides of the same coin, but I think that is a little bit different than saying, to the extent you might be concerned about parole, he would never be eligible for parole because of the way Arizona law works. So I think in a case where counsel argued that because of the way Arizona law works, this defendant would never be eligible for parole, that I think that might satisfy or answer Your Honor's question. Here it's a little bit different. So I think here we do need to go to the would probably have changed the outcome.
Well, doesn't, too, I mean, I'm a little concerned with the fact that it's just counsel's argument is sufficient when it's just defense counsel's argument. There's nothing from the court and there's nothing from the prosecutor. In this case, as I at least viewed the record, and in the face of it, you're getting an instruction to the contrary saying, well, if you don't sentence him to death, he'll get life with the possibility of parole after 25 years, that kind of thing. I mean, does it make a difference who's making the argument?
I think the point Your Honor makes about the instruction that a release eligible sentence could be available, I think that matters. So I think when you have an instruction from the court suggesting that there might be the possibility of release, I'm not sure that an argument by counsel itself satisfies Simmons in that scenario, but here it is relevant for the prejudice analysis. So that's where I think that comes into play here in this case, and why the state has argued that Mr. Rose has not met his burden and can't do so on this record of showing that a Simmons instruction would probably have resulted in a life sentence. I can turn to the intellectual disability issue next. While still trying to save a few minutes of my time. Here, in response to the questions the court posed to the parties, the trial court did not reach the intellectual disability issues because they became moot once the court granted relief. Now it's the state's position that grant of relief was erroneous. However, under the circumstances, once the court had ordered a resentencing, there was no reason for it to go on and address intellectual disability. As the court pointed out, that's something that Mr. Rose.
If we agree with you on that and say, okay, it needs to be, you need to make the decision, trial court, on the intellectual disability, do we need to address issues 5, 6, and 7, or do we just leave all that for the trial court?
I think those should be left for the trial court. Yeah, those. If the court had correctly denied relief on the Simmons claim as it should have, then it would have addressed those, and it should have the opportunity to do that if this course reverses.
And by the way, I invite your opposing counsel to respond to this if they disagree with what you say about this. But if we were inclined to rule on the intellectual disability challenges, should we wait for the U.S. Supreme Court's decision in the pending Ham case?
I think that would probably be a wise course of action, yes, to answer your question. If there are no further questions at this time, I'll go ahead and save the rest of my time for rebuttal.
Thank you. Mr. Mills.
Your Honor, it's John Mills for Mr. Eddie Rose. It was tough for the jury to sentence Eddie Rose to death. When he was 20 years old, he did commit a very serious crime to which he pled guilty, but it was still a tough decision for the jury because of what they had also just heard. They had just heard that at the time he killed Officer Cortez, that he was in the throes of a methamphetamine and mental health crisis, brought on first by the death of his mother, and then exacerbated when his abusive father kicked him out of the house, rendering him homeless. The jury still struggled, even though they were asked to answer the wrong question, whether to give Mr. Rose a shot at release. If they had been given information to which they were entitled to know, they would not have sentenced him to death. Your Honor, if you could address this case under Rule 32.1a, we asked the Superior Court to do so at page 41 of our petition. We asked it to do so again in our reply, and yet again in our bench memoranda in advance of oral argument. This was the first opportunity that Mr. Rose had to raise a Simmons claim after Lynch. He tried to raise one at trial. He made an objection at trial asking for an instruction. He tried to inform the jury at trial of his parole and eligibility. That was on October 13th, 2010. I believe it's page 101 of the transcript. They tried to tell the jury he can't get parole. State stands up and objects. Objection sustained. Okay, so this is not a scenario where counsel was able to inform the jury accurately.
Mr. Mills, let me stop and ask you procedural questions. This is a lot, and frankly, the fault might be with us, the way a lot of these questions are set up. But the third one was the one that asked about Rule 32.1a, which prompted my questions, were the were the Simmons issues raised under 32.1A? You said yes. And if I look at page 41, I'm going to find that you raised it.
Yes.
So assuming that, then the question that we posed here was whether any Simmons error in Rose's penalty phase was harmless beyond a reasonable doubt. Here, I've also seen issues from the state, or argument by the state that the 32.1A claim is precluded because it wasn't raised. And you addressed some of that, saying, well, it wasn't raised correctly, and at least raise it in terms of the ineffective assistance of appellate counsel. It seems that our question number 3 is putting the cart before the horse, resolving almost the merits before any of these procedural issues are resolved. Shouldn't we send this back to, if there indeed is a 32.1A claim under Simmons, send it back to the trial court to allow for these arguments to be made about preclusive effect and whether it should be framed under ineffective assistance of counsel, which is a very fact-intensive claim for appellate counsel, rather than us going on to address the merits?
Yes, Your Honor, I think there'd be a lot of wisdom in that for a few reasons. One, the Superior Court is going to have more time to wrestle with a large record in this case. And I think it also is very fitting in appellate posture to offer a rule and then allow the lower court a chance to apply the rule in the first instance. I think that would be very much in keeping with this court's practice overall. And it could allow this court to avoid offering a number of advisory opinions about provisions that may not even be at issue when we get back.
Okay, and then you heard my question, Mr. Sparks. If we agree that the trial court should simply have addressed and still needs to address the intellectual disability claim, do we need to address issues 5, 6, and 7, or just leave everything to the trial court at that point?
Again, we are in radical agreement with the state on that one. That 32.1A is available for applicants, and then let's just let the Superior Court work out how that is going to apply in this case.
Okay, so that just leaves us then, sounds like we're drilling down to simply issues 1 and 2 in terms of the, whether it's a significant change in the law. Really, number 2, then, if, is it the burden? Whose burden is it? And so could you address that, the interplay between 32.1G and 32.13?
Right. So, I mean, in this scenario, I'm going to ignore all the A arguments that I want to raise right now. Okay. So, but looking at G, the words probably overturn are different than the words used elsewhere in Rule 32. So if you look at 32.E, 32.H, it says, can the defendant show that the verdict would change? Probably overturn is different than that. And that makes sense because of how 32.1G operates within Rule 32. It is an opportunity to bring claims that seem appellate in nature, which this claim does in some ways, right? It's based on a cold record. It's based on a change in precedent. And so it's an appellate word, overturn. And that word is broad. It encompasses whatever standards of prejudice might be incorporated in the change in law. So the Valencia structural error, you're necessarily going to be harmless, is my reasonable doubt. A statutory change might have a different standard of prejudice. 32.13C provides, in the instance of constitutional law, a burden of harmlessness beyond reasonable doubt on the state. That provision doesn't get a lot of discussion in Rule 32 overall because most Rule 32 claims are like Strickland and Brady and come with constitutionally required burdens that necessarily meet the harmlessness beyond reasonable doubt on the state burden. If you've made out a Strickland claim, you've also met 32.13C every time. Same goes for materiality in Brady. And so we disagree with the state on which is more narrow and which is more broad. 32.1G allows for a range of claims, constitutional, statutory, or otherwise.
Counsel, let me ask you a question that I asked Mr. Sparks as well. So within the context of 32.1G and the Simmons claim, we look at, would it probably overturn the judgment or the sentence here? When we look at that, I asked whether we also then incorporate that requirement to determine, what would a reasonable juror have done? Do you agree that that sort of that's the inquiry we do to determine whether or not the application of Simmons would probably overturn the sentence?
I mean, I think that is the analysis that this court has basically undertaken in assessing prejudice, is like, how would having the right information about whether or not the defendant could ever be released have affected the jury? So if the jury's having a debate about, gee, do we want to give him a shot at release or do we want to kill him? We know that jurors are deeply concerned about a defendant doing the thing that they just convicted him of doing again. And so, that came up in this case during voir dire. One of the prospective jurors said, well, gee, you asked me about 25 years and then release. What if he becomes insane again and does this? I mean, I think that highlights very well how reasonable jurors respond to being told that release could be available. And I want to make a factual clarification about the colloquy, if I may, on this point. It was, I think I counted 8 times that the jurors were told that he could be released after 25 years. And then the state has said, oh, well, they were told it would be 170 years, term of years, right? Well, that doesn't appear in the colloquy. That takes the higher number of a group of ranges and then adds them all up. There's a lower number in each of those ranges, as well, as low as 7.5 years. And the judge in the same colloquy suggests that they might not be consecutive, that they could be concurrent. So the jurors would be very reasonable, an objectively reasonable juror, we assume will follow the court's instructions. And they were instructed that release after 25 years is a possibility. And they were still close, right? They were still close. And if they'd been given the right information, I don't think it's close. I think Mr. Rose prevails, whatever the prejudice standard is.
Well, in this, what you're talking about, the two different scenarios and argument, really to me, this seems to go right back to the burden. And so that's why I want to bring you back to the burden. At least for me, it kind of hinges on that. Yeah. And I wasn't sure of your answer to my prior question about the interplay between 32.13 and 32.1G. So from what I understood your argument about there's a difference between changing the verdict, overturning the judgment or the sentence, I think, until you answered Justice Montgomery's question and you said, yes, we do have to have the showing of what a reasonable juror have a different result in the sentence, and then you start arguing that they would have. So it comes back to, are you saying under 32.1G that it's the burden of the defense to make the showing that a reasonable juror would have decided the case differently had they received that instruction?
No, I'm not making that argument. In response to Justice Montgomery, I was just trying to say that, hey, when we're looking at how this lack of accurate information affected the case, and whether the state can meet their burden, sure. Let's look at how this reasonably played out in light of an objectively.
So your position is under 32.1G, that doesn't mean that you have the burden to show that it would have been a different sentence. It's simply that if the Simmons error had occurred, it would have overturned the sentence in order to,
which would then incorporate whatever the appellate standard is.
The prejudice, right. So then if you made that showing, you go to 32.13 and have the hearing, and at that point, it's up to the state to show harmless error.
Yes,
is that your position?
Yes,
okay. Then under 32.1G, what does the latter part of that provision add to the rule? In other words,
probably overturn. Yeah.
Why can't you just show there's been a significant change in the law that applies to the case? What does it add then to show that would probably overturn the defendant's judgment or sentence?
Well, so a significant change in the law does have to apply. So that's the first part. Obviously, we agree on that 100%. But the words probably overturn speak to what the job of the Superior Court is to do, which is to look at, okay, Lynch was decided, did it, and it could apply to this case, and I think the word applicability this court has used to address retroactivity concerns, right, under T. So I think the first question is a bit in the abstract, right? Does it apply to this case? And then probably overturn is, okay, now we're going to do the Simmons analysis. We're going to do the Lynch II analysis. We're going to do the Valencia analysis, the Montgomery analysis, as you did in Valencia. And so I also think of overturn, or probably overturn, as a way for the Superior Court to have some humility and say, look, I don't know what some past version of the Arizona Supreme Court would have done if they had had Lynch II when this case, reached them. But would it have probably overturned it? And if they can answer that question, yes, with faithful application to Lynch II or whatever the significant change is, then it becomes the obligation of the state to meet the prejudice burden if it's a constitutional question, to get back to 32.13.
Okay.
And that would reinforce the additional constitutional requirement to give defendants at least one opportunity, right, to have Chapman versus California apply to their case. Mr. Rose has now had that opportunity because when he first appeared before this court, he was foreclosed by Cruz I. And so this is his first opportunity to have Chapman apply to his Simmons affair. So, I think given our agreement on Atkins, I guess I just want to reinforce a couple of points on why not having accurate information was important. So, in this court's analysis in Escalante Orozco, the jurors, Mr. Escalante Orozco was 40 years old. This court said, well, that's young. Mr. Rose is 20. The crime involved a sexual offense and a murder, and then pre-trial, Mr. Escalante Orozco threatened to hold a female prison guard hostage. And the jury nonetheless deliberated for 13 hours, and this court said, okay, that's not, the jurors were entitled to have the right information and probably affected their case. It was not harmless error. In Hulsey, the defendant was 33 years old, involved 2 law enforcement victims, and the jury deliberated for 8 hours. In Rushing, it was a defendant who was serving life without parole already and committed a grievous murder, grotesque murder, at the age of 35. The jurors deliberated for most of a day, and in that case, defense counsel did tell the jury that parole was unavailable. This court, reversed, finding non-harmless error. But for Mr. Rose, the jurors deliberated for 15 hours and across 3 days. He was 20 years old. There was profoundly mitigating evidence offered regarding his mental illness, regarding his cognitive impairment. He had a conceivably colorable claim of intellectual disability. And the jurors, if they had been given the right information, would not have sentenced Mr. Rose to death.
Now, I understand that's your argument, counsel, and I appreciate it. But with respect to the other cases that you mentioned, it feels a little bit like a proportionality review or a proportionality analysis, which is something we don't do. And I wonder, though, with respect to weighing the mitigating and aggravating factors, this court, when Rose came before it on direct review or for direct appeal, paragraph 78, found that the state had presented evidence to rebut much of the mitigation and concluded that a reasonable jury could find that the mitigation didn't call for leniency. And so, I wonder, with that being distinct from the other cases that you mentioned, if in looking at, and this is why I asked the question, and look, I readily admit that when we try to discern a consistent principle in the federal Supreme Court's Simmons jurisprudence, it can be difficult. And in litigation before this court, there are so many different characterizations of what the Simmons holding is and what's important, what to focus on, that both sides can make perfectly legitimate and intellectually honest arguments here. But my question is, acknowledging that there was no specific Simmons instruction given, what are we to do with all the information that the jury did get? I understand what your argument is on it, because you made it very, very plain with your particular recitation. But it seems like there was more information that was provided to the jury here with the colloquy itself, with defense counsel's reference to the non-murder count sentences and everything else that would permit a conclusion that even if the jury had been explicitly told about the defendant's release eligibility, that they were still somewhat aware of it, more so than any other jury in any of the Simmons line of cases. What do I need to take into account to reach the conclusion you want me to reach?
Well, let me, gently, maybe forcefully disagree with the premise. So in Schaefer, for example, at page 52 of the U.S. Supreme Court's case, it notes that the jurors learned that life means death in prison, and they still reversed. Okay. In Rushing, counsel told them explicitly, parole not available, still reversed. Here, the only effort by trial counsel to say parole is not available received a sustained objection by the state. And I would ask the court to hold, as it always does, that jurors are presumed to follow the instructions they're given. And the instructions they were given here is that Mr. Rose could be eligible for release after 25 years, which this court has also held constitutes misleading the jury about the availability of parole.
Well, and I'm curious about that, because during that plea colloquy, the court actually went so far as to say what would happen, or what would have to happen in order for release to occur. That, there's a board of executive clemency, that there's a board of pardon and parole, that in order for any release to happen, then they would have the recommendation, and then the governor would have to exercise discretion. So it seems to me that that's another fact that is somewhat unique here that we don't see in any of the cases, where the jury just didn't hear about it, but they actually heard the mechanics of it.
I mean, it is unusual to have a plea colloquy played for the jury. I'll grant it, Your Honor. And I think it's fraught with peril in some ways, in ways that we're seeing play out today, because the jurors, were told possibility for release after 25. We're told very low ranges of sentences. But what to do with, there's the possibility of executive clemency, there's the possibility of this. I mean, I would ask the court to look at the instructions the jury received before they went to deliberate on whether or not to execute Mr. Rose. And to stick with this court's jurisprudence about what those instructions did for the jurors. And what those instructions did was mislead them into answering the wrong question. They weren't asking whether to sentence him to prison for the rest of his life or to be executed. They were deliberating about whether to give him a shot at release. And that scares jurors. The state is very effective at making jurors scared about that, and understandably so. But if the jurors had given the right question, they would not have sentenced Mr. Rose to death. Thank you.
Okay. Thank you, Mr. Mills. Mr. Sparks.
Thank you. Just a few points. I think the applicability piece of 32.1G does more than Rose is arguing that it does. Sure, the retroactivity is part of it, as this court has discussed in its case law, but there's more for it to do as well, because you can have a change in the law that is retroactively applicable, but you still need to look at, does that specific change in law apply to the defendant's case? There are two things required for Simmons to apply to a particular case. One is the defendant parole ineligible? And two, is future dangerousness at issue? So I think those are parts of the applicability piece of 32.1G that Rose has to establish when applying the rule.
What does 32.1G, when it says there's been a significant change in the law that, if applicable to the defendant's case, and I'm wondering, what does that add to it? Why not just say there's been a significant change in the law that would probably overturn the defendant's judgment or sentence? And that's how you're arguing that that's required. So what difference does it make to have that if applicable to the defendant's case language?
I think it expands the inquiry. I think it's making clear that you need to look at the particular facts and circumstances of this defendant's case and say, all right, we have a change in the law. First, before we go any further, does it apply here? And to do that in the Simmons context, Rose has to show, first, that he's parole ineligible, and two, that future dangerousness is at issue. Once he's shown that Simmons, this change in the law applies to his case. But to say, okay, now he's established he was entitled to the instruction, the state has to prove harmless error under 32.1C, that rights would probably overturn the judgment or sentence right out of the rule. Leaves it for nothing to do. So under these circumstances, once he's shown that, yes, Simmons does apply to the particular facts and circumstances of his case, that's when that final clause of the rule comes into play. And the only thing left for it to do here is, okay, if the jury had been so instructed, would it probably have overturned?
Of course, if it would probably overturn the defendant's judgment or sentence, it obviously implicitly applies to the case, doesn't it?
I think so, but the rule incorporates all of it. So I think to apply the rule, that full analysis needs to be done. With that, we would ask the court to reverse the judgment of the Superior Court and to reinstate the death penalty.
But you're okay with saying it back on Adkins, though?
That's correct on those.
Okay.
The
So
claims
you
that were
want
never addressed.
Okay,
Right.
got it.
Right, just on the sentence issue.
Yeah, go ahead. One more question.
I burned a lot of your time at the beginning. I wanted to ask one more question, though, with respect to Atkins. If we don't accept the premise that Gates/Altamirano allows for asserting a right to an intellectual disability determination on collateral review, is the state, because I saw the state, willing to go back and fight all this all over again, but did the state give any thought to the fact that if we stick with 32.1A and 32.2A, that given the waiver during the trial and sentencing phases, that this Atkins claim is waived? Ineffective assistance of counsel aside for a moment, but that it's waived, and that for Eighth Amendment purposes, the defendant still would be able to raise the issue prior to an execution under ARS 13-4022.
We did give thought to the waiver issue, Your Honor, not specifically the interplay of the statute that you mentioned, and that was what we were getting at in the portion of the briefing where we were looking at waiver and would a claim under 32.1A be precluded. And this is an issue where I think waiver is difficult. You have the question of, can an intellectually disabled defendant waive the right to present that?
Well, I think that's separate from whether or not this particular right is a knowing, intelligent, personal waiver, because it is fraught with some problems there, as you allude to.
Right, and I think that reason that you're pointing to, Your Honor, is the reason why. Again, because these waivers become important not just for the Rule 32 proceeding, but further in federal habeas corpus proceedings down the road. And for that reason, the state is hesitant in a situation like this to argue that the 32.1A claim is definitively waived. And
from my prior question, I just got your position is that you agree to simply send it back and have on Atkins and on the issue 4, and then 5 through 7, we don't decide, let the trial court decide it first.
That would be a perfectly acceptable way to resolve it at this point, Your Honor, yes.
Okay, questions? No, thank you. Thank both counsel, all counsel, for your briefing and your argument today. We'll take the matter under advisement and issue a ruling in due course, and we'll stand adjourned for the day.